5 seconds to go. Start. Every day's delay must be explained does not mean that a pedantic approach should be made. Stop. Why not every hour's delay, comma, every second's delay? Sign of interrogation. The doctrine must be applied in a rational, common sense, pragmatic manner. Stop. When substantial justice and technical considerations are pitted against each other, comma, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of a non-deliberate delay. Stop. Para. There is no presumption that delay is occasioned deliberately, comma, or on account of culpable negligence, comma, or on account of malafidis. Stop. A litigant does not stand to benefit by resorting to delay. Stop. In fact, he runs a serious risk. Stop. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. Stop. Para. The Honorable Supreme Court has formulated some principles for condonation of delay as follows. Stop. From the aforesaid authorities, the principles that can broadly be culled out are colon para. There should be a liberal, comma, pragmatic, comma, justice-oriented, comma, non-pedantic approach while dealing with an application for condonation of delay, comma, for the courts are not supposed to legalize injustice but are obliged to remove injustice. Stop. The terms sufficient cause should be understood in their proper spirit, comma, philosophy and purpose, regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective to the obtaining fact situation. Stop. Para. Substantial justice being paramount and pivotal, the technical considerations should not be given undue and uncalled for emphasis. Stop. No presumption can be attached to deliberate causation of delay, but, comma, gross negligence on the part of the counsel or litigant is to be taken note of. Stop. Lack of bona fide imputable to a party seeking condonation of delay is a significant and relevant fact. Stop. It is to be kept in mind that adherence to strict proof should not affect public justice and cause public mischief, because the courts are required to be vigilant so that in the ultimate eventuate there is no real failure of justice. Stop. The concept of liberal approach has to encapsulate the conception of reasonableness, and it cannot be allowed a totally unfettered free play. Stop. There is a distinction between inordinate delay and a delay of short duration or few days, comma, for to the former doctrine of prejudice is attracted, whereas to the latter it may not be attracted. Stop. That apart, comma, the first one warrants strict approach, whereas the second calls for a liberal delineation. Stop. Para. The conduct, comma, behavior and attitude of a party relating to its inaction or negligence are relevant factors to be taken into consideration. Stop. It is so, as the fundamental principle is that the courts are required to weigh the scale of balance of justice in respect of both parties, and the said principle cannot be given a total go by in the name of liberal approach. Stop. Para. If the explanation offered is concocted or the grounds urged in the application are fanciful, comma, the courts should be vigilant not to expose the other side unnecessarily to face such a litigation. It is to be borne in mind that no one gets away with fraud, comma, misrepresentation or interpolation by taking recourse to the technicalities of law of limitation. Stop.